Hello and welcome to this CTC Leadership Team's Continuous Professional Development webinar. We're running this webinar in April of 2021. And as you can see, if you're following the slides while you're listening to the webinar, the session objectives are to gain an update in relation to the law and legal areas of interest, especially to CTC leadership teams as the employer, to understand leadership roles and limitations of those roles and decision-making authority levels in CTCs, and to develop a clear understanding about before, during and after what you might undertake as a member of that management team when it's a matter connected to employment. So just to give you a brief idea in terms of the context of what the law is and how it works in Ireland, I'm not going to read through the whole slide, but you can see there's an amalgamation of different areas of law that impinges on the relationship between the employee and the employer. And all the different rules that are governing are sourced from contract law. So it could be an express contract law or implied. Implied is something in your contract that may not be explicitly stated. It's implied, whereas express is it's actually stated clearly. There's also tort law and negligence, and it's about the duty of care to each other, and of course legislation, which is heavily regulated. I want to just mention pre-employment issues that need to be considered by CTCs as employers, and that could include something to do with work permits, for example. There's plenty of information available on the different government departments' websites, and your local ETB will be able to help you with that. Interview issues in terms of ensuring that you use the correct and appropriate best practice guidelines in terms of interviews. So we have produced a suite of those guidelines, which you will be most likely familiar with, in terms of helpful shortlisting guidance and templates, and then some competency-based interview templates that you can use that shows the panel that's recruiting to whatever the post is in the CTC have used a fair process. We don't undertake medical screening in CTCs, so I won't say much about that, if anything. And of course, we do undertake Garda vetting for all posts connected with the CTC. If your organisation as a CTC, it's unlikely that you're set up as an organisation that can conduct its own Garda vetting, in which case your local ETB will help you as an umbrella organisation access the paperwork that you need in terms of the Garda vetting process. We've also talked about the Companies Act in 2014, and I know there's another corporate governance webinar that you can look at in terms of what's been codified under that legislation, so we won't really say much about that. Give you an idea of the different principal courts that deal with employment issues in this country. We've got the District Court, the Circuit Court, the High Court, and the Court of Appeal. Now I'm actually going to make reference to a Supreme Court judgment, very recent one, because it has an impact on one of the slides I'm going to talk about in a moment. But in terms of the WRC, which is the Workplace Relations Commission, which we'll talk about, that's really there, and the Labour Court are where we're really going to be focused in terms of being an employer. Workplace Relations Act 2015, it consolidated the 5 employment rights bodies which had been in existence prior to that period, and it brought it into 2, in essence the WRC, which is the one you might be familiar with, and the Labour Court. So it did result in the consolidation of the different roles and functions going into the 2 bodies, and we'll become familiar with that as we move through this. And I mentioned a moment ago the landmark judgment very recently in April 2021 actually, and it's basically a case that was taken, and it does have a repercussion, and we need to be clear about that. It was a case taken by a man called Zalewski, and the adjudication officer, and it was on the 6th of April 2021, and what happened was this person was employed in a capacity and took a case in terms of how his own employment case and leaving his employment had been handled very poorly. And what happened was eventually the case worked its way up, and the Supreme Court ruled very recently in a very huge landmark judgment, and that will have an impact, that the Workplace Relations Act, which we're working to and under as CTCs, for example, is not unconstitutional. And everyone was a little bit worried about that and whether that might happen. Mr. Justice O'Donnell ruled that the WRC does not offend the Constitution because it does comply with Article 37 of the Constitution. And in essence, the judge ruled that the WRC is in the administration of justice, but that its powers are limited in at least 5 important ways. Now, I'm not going to go into those with you, but I just need you to realise that, the removal of a blanket ban on private hearings, cross-examination, and the provision for adjudication officers to take evidence on oath was very clearly outlined through this landmark judgment. And the changes will apply to employment rights cases, not industrial relations claims, which are taken under a very specific section of the Act, where an employee can refer a trade dispute to the Workplace Relations Commission. And I've given you an idea about what a trade dispute is, and we'll talk about it a little later on. But you may be asking, what are the implications of this landmark judgment? Well, really, the judge said that proceedings may, but not must, be heard in public. So what it will mean is that the WRC has informed their adjudication officers already that parties to an adjudication can actually share the WebEx link to the hearing with members of the public. So you'll be aware a lot of cases at this moment in time due to COVID are still being held virtually. And the WRC will share the WebEx link that invites the parties into the virtual hearing. And what this ruling says is that adjudication officers will advise the parties that they can share that link if they wish to with members of the public. Now, you can imagine how people might feel about that in terms of what they want made public or not. So I'll say a little bit more about that in a moment. The court also noted that taking evidence on oath triggers the power to punish for false evidence. So actually it's an incentive to truthful testimony. So that may be helpful. I mentioned trade disputes earlier on, and just to say to you, the main legislations, for resolving disputes under the Industrial Relations Act are all listed there for you, and it gives you an indication of what those trade disputes come under. The WRC process, which is the one you're more familiar with, I would imagine, and let's hope as an employer you're not using this process too often. However, it is about where complaints and disputes can be investigated by means of an inspection. Now, there is a facility in the WRC for a case to be referred to a mediation officer in an attempt to actually resolve it a little bit quicker. And the WRC Director General will make that decision when they receive a claim, and they will actually, either refer it to a WRC mediation officer or onto what we've come to know and be more familiar with as an adjudication officer, who will hear and investigate the claim. I'm moving on to contracts of employment now, just to give you an indication of what the contracts of employment must contain. And since the 4th of March, a couple of years ago, a person has to receive part of their statement containing the core terms of employment within the first 5 days of starting a job. And then they must receive the remaining terms in writing within 2 months. Look, in CTCs, you'll be familiar, those of you who've been involved in recruitment in recent years, that IACTO provide draft statement contracts for you to utilise, nationally agreed contracts of employment, and we update them and customise them as you need, as you appoint staff and in particular general managers. So some of you will be aware of that. There is a nationally agreed one. There are very specific sections in it that relate to CTCs. So if you are recruiting staff to your CTC, I would advise you strongly to check in with the IACTO office and make sure you're working off the most current up-to-date template, because they have changed over the last number of years on occasion. For example, there was information about annual leave that changed. There was information about retirement ages and other types of family leave. So you need to make sure you're working off the correct contract of employment. I did want to say a little bit about fixed term contracts, because sometimes they're misunderstood, and they have the same employment rights. Sometimes people misunderstand that and they think a fixed term contract doesn't carry the same employment rights as an open-ended contract. Now, an open-ended contract might also be known as, a permanent contract, or a contract of infinite duration known as a CID. So just to give you the terminology, if you have a permanent CTC vacancy, you tend to recruit and offer a permanent contract. However, a fixed term contract can also involve a specified purpose. So it may not just end on a specific date, which the fixed term would give you that implication that it's fixed for a term of time from X date to Y date, but you can also have it for a specific purpose. For example, maternity leave, there's a specific purpose, or if you have to cover a long-term absence of a permanent employee, you might offer a specific purpose contract to say that when that particular instructor who has a permanent contract returns to the workplace, the specified purpose contract comes to an end. Again, strongly advising you to make sure you link in with IACTO, who will have the most up-to-date types of contract that you may require in terms of employing people in the CTCs. Other legal updates of interest for you, as you can see listed there, they don't really apply to us. We don't need to worry about 0 hours contracts in essence, but just to give you the information is there. There were changes to the Family Leave Bill. I would have highlighted for you previously that those changes were coming. They're now here, so I'm going to talk about them in a couple of moments. There's also new codes of practice coming into play, and I'm going to list those in a couple of minutes for you also. So to give you the summary of the family leave, for your information, parental leave, which we already have in a CTC, but now there's an entitlement for 26 weeks unpaid leave for children under 12 or 16 if the child has a disability or a long-term illness. And I've put a note there that there's a new additional entitlement of 8 weeks unpaid for the CTCs, because at the moment in our handbooks it references 18 weeks unpaid leave. So we have done a family leave summary, which we will send on as a handout after we send you the link for this webinar, and it clearly states the 7 types of family leave, and one of them is parental leave. I just wanted to highlight a couple for you today. Another one that there's been a change is called parents' leave, and that's 5 weeks leave where the employee can apply for parents' benefit from social welfare, and annual leave and public holidays continue to accrue while the person is on parents' leave, this 5 weeks parents' leave, and they have the right to return to the same job. We also look to paternity leave and changes under the family leave, and they now are entitled to 2 weeks leave where they can access paternity benefit from social welfare again. Now this is new for CTCs because we already have 3 days paid paternity leave in our handbook. So this new 2 weeks leave is in addition to that. because the 2 weeks they would have to access payment from social welfare, not from the CTC. So just to recap, CTC staff will get 3 days paid paternity leave currently, and in addition to that they can now apply to have the 2 weeks unpaid from the CTC paternity leave also. Again, annual leave and public holidays accrue and the right to return to the same job. So as I said previously, there is a handout available of a table which outlines the summary of the different types of family leave for you. Just to talk about areas of legislation and the different types of leave that any member of staff can access. It's governed by 8 specific areas of legislation, and they have statutory entitlements to a number of different types of leave. So I wanted to list those out for you, and all of these are referenced in the CTC employee handbook or in the previous slides that I've just gone through with you. To make us all aware of the different employment law and codes that we need to be cognizant of going forward, because there's a lot going on at the moment. Employees have the right to request to remote work, and government are looking at a strategy and a roadmap. They had started a consultation period actually in December 2020, and they're looking at further guidance being made available to all employers. So we're waiting for that to come through. If you want to look up a bit more about the remote working, the UK have that enshrined already, and we suspect that what might happen here in the Irish context is our request to remote working is going to look pretty similar, I would imagine, to the UK's. But please note, it's the right to request the remote working. It doesn't give an automatic entitlement to have that request acceded to. So you need to be really clear that though the employee gains the right to request it, you as the employer have a number of duties placed on you to consider it and put reasons if you have to refuse it in writing. But as I said to you, there will be more guidance coming through on that at some point in 2021. Coming into effect already, 1st of April 2021, is the Code of Practice on the right to disconnect. So you've heard a lot about this, I'm sure, in the newspapers and in the news in recent weeks. You'll have noticed, and I think it's in the IACTO emails also, that there's little messages popping up on a lot of footers in emails from all sorts of organisations that says something to the effect of, if you receive this email out of your usual working hours, we're not expecting you to respond until you're due back to your usual time of work the next day. And this is all about employees having the right to disconnect from work. It became pretty prevalent, especially during the last year when a lot of us were remote working as required by the level 5 restrictions and government and managing the COVID-19 situation. And what was transpiring in some workplaces was that employees felt they were always on. They always had to respond really quickly to phone calls or emails. And this new Code of Practice makes it very clear that there's a right to disconnect. And you cannot expect somebody to respond to you by email or by telephone or whatever if they're off work, and if they're not in their normal working hours. There are proposals expected by the end of 2021 on the statutory sick pay and changes to notification periods and, when the statutory sick pay is triggered and how many days they have to wait. Look, at the moment, the employee handbook states very clearly the CTC employees' right to sick pay and what we will pay. So we'll wait and see what the proposals are as the year rolls out to see if we need to have a look at when that might be triggered in terms of notification and how many days we need to be made aware of in terms of somebody's sick pay. There's also the Code of Practice on the prevention and resolution of bullying at work, and I'm going to talk about that in a moment. I wanted to mention the domestic violence leave and the codes that might be coming down the line in terms of that. More relevant if our employees were going to stay working remotely, but that's not going to be the case. In most employees' situations, we're back to our centres to work. And it would be only a significant employer concern if the home was going to be the workplace on a continued basis or on a regular basis if there happened to be domestic violence occurring or the employer was made aware of it. But we're not going to say too much more on that. There's significant concerns and clarifications are going to be needed for employers where they have employees working mainly in the home as their main workplace. The whistleblowing directive, the EU one in 2019, it's actually due to be transposed into our own law by the 17th of December 2021. And there are some changes in terms of what's expected to come down the line. So at the moment, you'll remember that the whistleblowing, which I'll say a little bit more about later on, is applicable to employers who are public employers, but that's going to change. So we'll come to that in a moment. Gender pay gap information bill for information, and then there are initiatives around retirement which we'll say a little bit about in a moment. I wanted to go back and revisit the code of practice on workplace bullying. I'm not going to read everything that's on that slide, but I do need you to be aware as an employer, whether you're in a general management role or whether you're in a voluntary director role, that you really do need to be aware of the changes and the new code of practice. It's really important that you have an understanding about that and what is the implications are for CTCs. And on this slide, I'm showing you what the new code complaints process is. Now, the difference in CTC handbooks is this new code advises us to have a secondary informal process. Clearly, it's going to depend on the case that's in front of you at the time, but we in general would comply completely with this new code in a CTC handbook. However, there would be an expectation to have another go at trying to informally process a complaint if possible. Again, I'm going to suggest to you all that you pick up the phone, email us, whatever you need to do to get in touch with IACTO should you receive any sort of complaint from any member of staff, so that we can make sure that we're complying with the new code in terms of how the CTC board as the employer is managing the complaint or the grievance or whatever it is that you've received. So please make sure you're really aware of that. And of course, mediation is going to come more to the fore because, you know, the WRC, as I mentioned earlier on, may assign a case to mediation, but also with the new code, there's going to be a huge drive to try and resolve complaints at an informal level at mediation rather than go to a very formal process in terms of a WRC. Just talking about certain criminal convictions here and reminding you all about the Criminal Justice Spent Convictions and Certain Disclosures Act 2016. Really important that we have an understanding, and you'll remember this from the Garda vetting sessions that we delivered when those changes came into play for CTC staff a couple of years ago, in terms of the following offences that will never become spent in terms of working with, you know, young people, vulnerable young adults, and they would be around convictions for a sexual offence, an offence that had been tried in the Central Criminal Court, or an offence that resulted in a prison sentence of greater than 12 months. So you'll be aware we have to vet all CTC staff now, and I mentioned that earlier on. I briefly referred to the whistleblowing directive, and I talked about it being transposed into legislation by the 17th of December this year, 2021. And one of the big shifts is around encouraging whistleblowers by offering more substantial protections. And also the Act introduced a new form of interim relief where the employee that's claiming to be dismissed for having blown the whistle, if that happens, they could apply to the circuit court to restrain the dismissal pending the outcome of the unfair dismissal claim. But the main thing to remember for you as a CTC is that the directive will extend the obligation to the private sector in terms of having a whistleblowing policy in place. So just to be aware of that, it's a piece of legislation to watch. And there I've just given you a reminder of the Unfair Dismissals Act that I mentioned previously. 3 types of dismissal: fair, unfair or constructive. You may be aware of some of these already, and I've listed what the remedies would be in terms of depending on the outcome of the case. But just to be really, really clear, in terms of somebody taking an unfair dismissal case, it must be referred within 6 months of the dismissal date, and they must be able to establish that they have 1 year's continuous service in order to take a case. It's just a slide showing you all of that. And just to remind you that the dismissal may not be unfair if it results from capability or qualifications, conduct, redundancy, or a legal impediment to continued employment. So, just because somebody takes an unfair dismissal case against an employer doesn't mean the dismissal will be found to be unfair. It could be found to be fair. Reminding you about the Employment Equality Act, we've already considered this very closely in our Dignity at Work webinars. So if you want to find out a little bit more about this, we say a lot more about it in that webinar. But just to remind you, it outlaws discrimination on 9 grounds. There can be direct and indirect discrimination. And it's worth you tapping into the Dignity at Work webinar, because we go into a little bit more detail about neurodiversity also, and that's really important that employers have an understanding about that. Reminder really of the Organisation of Working Time Act, and there are inspections starting to happen whereby somebody can come in and ask you legally to show your records. So I'm quite confident all CTCs are already complying with this Organisation of Working Time Act. We would have spent a lot of time in the previous couple of years making sure you all understood it. We've brought it up year after year to remind you that there has to be a system in place. If you're not recognising what the paperwork is that needs to go alongside you complying with the Organisation of Working Time Act, I suggest you go back and you speak to your board and the general manager and find out what the system is if you're unclear, to make sure it exists in your CTC. I've given you some information about records, and we actually have some standard forms which you can download off any of the government websites yourself. But if you need some support with starting that process, please God you have it already in place. But if you happen to find out that it's not in place and you need to start doing it really quickly, then I would suggest you get in touch with the IACTO office and we can help you get started. But I would hope that that's not the case in any CTC across Ireland. Little bit about retirement, because we've had a bit of discussion about this because there was a bit of a U-turn done on this by government. You'll be aware the normal retirement age in our CTC contracts is 65, and then when government said they were going to change access to the state pension, and they moved it up to 66, and then they had planned to move it up to 67 and 68, we actually matched our employees being able to stay on if they wished to in the workplace until they could access the state pension, for example, at age 66. So that's already in place in CTCs. So we already have the option to extend the retirement age from age 65 on a voluntary basis. The member staff has got to want to do it. They don't have to. They can retire at age 65 if they wish to. But if they wish to stay on till age 66 only, that's because it aligns with the current age of entitlement to the state pension, then we have a procedure to allow that. GDPR, reminding you about the different rights for individuals. Hugely important that you make sure your CTC is complying with GDPR regulations because of all the information that they store, not only in relation to employees, but in relation to maybe board members, in relation to learners. You know, there's all sorts of information that's stored. So you need to make sure your general manager is managing this side of the house on behalf of the board, because they're the day-to-day person who would be expected to be compliant with GDPR. This isn't a new right, the right for people to access their data. It's not new. However, there are very clear procedures about timescales. So you need to be really clear about, if you do get a data access request, that the clock is ticking from the moment they give that request. So please make sure all board members and general managers are aware of the clock ticking in terms of what they need to do. And don't forget, your information on computers, laptops, you know, your servers, all falls in under GDPR now. I'm just giving you a little bit of information in terms of Article 6 and the legal basis, but we've already done huge workshops on GDPR over the last number of years with CTC managers. 6 legitimate reasons by way of a reminder in terms of processing personal data, and you can see there I've highlighted them in red for you. And in terms of consent, just to say, CTCs as employers should not and cannot make consent a precondition of a service or of employment. So you can't make, you know, a new employee coming in consent to something, or else they won't get the job, for example. So you just need to be aware of that. There must be no negative consequences to an employee withdrawing consent to hold data either. Look, we looked at this before. We've done a session on this. You have the information already. And if you need any refreshers as the course of 2021 rolls out, please ask at the main office in IACTO. Give you an idea of the data breaches. And what does it all mean? So for CTCs, that was a very quick gallop through employment legal areas of interest really for 2021. And really what we're saying to you all is try and attend the briefing sessions that we provide across the year on different themes. We've also recorded some short webinars for you. This is one of them, to try and help get the message out there and be more convenient for managers and directors to actually hear the information. I would suggest you have it on a board report as a standing agenda item under corporate governance, you know, in terms of any of the items that we've discussed in this employment law refresher. Identify wherever your gaps are and, you know, start to look at planning how you're going to address those gaps. Try and get yourself involved, if possible, in any policy and procedure project groups that are going on with IACTO. You'll remember IACTO lead out on those project groups in terms of the needs of CTCs, where we need to develop templates that would be helpful across the CTC network. We pull together a project group, and the information forums that, you know, are on offer to you all every quarter will give you a reminder of the project groups that are up and running for that particular time period and give you an update on where it's all at. And then the last thing to say to you is to work with us in terms of managing cases. Case notes are really important. Record the interactions in a data compliant manner and make sure you get in touch with us as your HR provider earlier rather than later if you're having any issues or problems. So the next steps: discuss whatever updates are required for your board and your centre going forward, and see if we have something scheduled already, because we do tend to schedule all of these types of workshops or record webinars based on themes that you've actually identified already. So thank you for becoming involved in helping us set that work plan up. we would have gathered information on all of your CPD needs from the 2020 evaluation forms, from different forums that we had with you, from different workshops, and indeed from general managers identifying themes and needs at the regular operational management meetings that they attend. But look, if you think of something else, and if we can, we'd certainly try and, you know, either organise it for you, organise it regionally, organise it nationally, whatever works. We certainly do our best. So thank you for your continued support and for listening to the webinar.